Hello, everybody, and welcome to Crafting Your Craft Brewery's Employee Handbook. I know I'm extremely excited for today's session with John Hyman of Wickens Law. This is the latest installment in our series with Laura Lodge, Candace Moon, and the wonderful people and content over at Start a Brewery. And Laura, I'd love for you to share a little bit more about what you're doing over at Start a Brewery.
Absolutely. Thank you for having us. And I'm appreciating this partnership and getting these educational webinars out. I think it's super cool. And I think today's topic lends itself so well, not only to startups, but to people who are currently operating their breweries. I think this is an area that most people don't necessarily come in the door knowing a lot about. So I'm looking forward to it as well. Start a Brewery, Candace and I began with the idea of raising the bar for startups in terms of quality through education, and have also in the process found that we are lowering the barrier to entry for those who don't have a goal or a path or a way to approach their dream. And I think all the contributors who have been, like yourself, Andrew, like John, have volunteered to share their wisdom and their expertise through all of their years of work with the industry and adjacent to the industry are making a big difference.
So,
So
Laura,
thank you.
of course. So, for anyone looking to learn more about Start a Brewery, where can they find all your community and content?
Startabrewery.com. And we just released episode 004 of our podcast. And today's educational webinar is the second in our series quarterly. So super excited to have John today and for his knowledge and experience in the industry of employment law.
So, John, who are you and what are you going to be talking about today?
What is happening, everybody? My name is John Hyman. I am a lawyer, but don't let that scare you off at all from listening to me chat with you all for the next hour or so about employee handbooks. I am with the firm Wickens, Panza. We are in Avon, Ohio, which is just to the west of Cleveland on beautiful. And today, as I look out the window, sunny and warm, Lake Erie. I've been a practicing employment lawyer for 25 years. I chair our labor and employment practice here at Wickens. I also co-chair our craft beer practice group, which I co-founded as well, representing breweries both in the startup and established space, not just in Northeast Ohio, but all over the state and on a national basis as well. My contact information is here. If anybody has questions, please drop them in the comments. We'll kind of take them as they go if they fit. If not, we'll save them for the end of the presentation today. But if there's a question you don't want to ask, don't want to have answered publicly, feel free to hit me up at any or all of the ways you see here. And literally, like, I don't hide. If you just Google John Hyman lawyer, you will absolutely and very easily find me. So the topic for today is crafting your craft brewery's employee handbook. And, like Laura said, it is while we are, and thank you to Laura and Start a Brewery and Andrew at Craft Beer Professionals, if I didn't say that already, for having me today. And while this is co-branded with Start a Brewery, this is while a handbook is something you should be thinking about when you're in startup phase, it really, and what we're going to be talking about today, really cuts across breweries of all sizes and in all stages of their development and establishment. The first thing we need to decide when we're talking about how we craft our craft brewery employee handbook is why we want to have an employee handbook in the first place. Like, what's the purpose of it? Why do we need it? What goals are we trying to achieve? On the what is an employee handbook, it is an aspirational and expectational set of policies and guidelines, bilateral. It works both as guidelines and expectations for you as the brewery owner, for management to follow, as well as for your employees to follow. It should be written in plain language. It makes it easy for employees to read and follow and understand. It should be multilingual. Whatever languages your employees speak as their first languages, those are the languages the handbook should be written in. And most importantly, from a legal standpoint, the employee handbook is not intended to be, nor should it be construed, read as, understood as a contract between you, the employer, and your workers, the employees that work for you. If you want to have it as a contract, that's your prerogative. As long as I've been a lawyer, I've never had a business, brewery or non-brewery, tell me draft me an employee handbook as a contract. You don't want this handbook to bind you in any way, shape, or form. You want it to be guidelines, so you have the rules of the road between you and your employees on both sides understood, but you don't want it to lock you in to such that if you don't follow it, it will set you up for a breach of contract lawsuit, a claim to be filed by an employee saying you breached this handbook. And we're going to talk in a second about exactly how we craft this, so it's not, and so it's not a contract. And lastly, I think it's important to point out that the handbook should match the tone of your business. If you're, I suppose there's a formal, stuffy brewery out there, I suppose, in the craft space. And if there is, have the handbook match your style, match the tone of your business. But for the most part, we're in this industry because we love the fun space that we all get to play in the craft beer industry. And let's have our handbook match the tone and style of our business. It should be conversational. It should be easy to read. It's as you're giving this to employees on their way in the door on their first day of employment, it is in many times kind of your first kind of corporate outreach to your employees. And so you want it to not scare them off. You want it to draw them in. It should be written as such. I want to make one quick point about online forums. And every time I say this, people say, John, the internet's a broad place. It's a wide place. We can do a Google search. We can ask ChatGPT to write an employee handbook for us. We don't need a lawyer to do this for us. You're just trying to create business for yourself. And I'm plenty busy. I don't need to make work for myself. But there's lots of reasons why you should be cautious with going to Google and asking Google to find an employee handbook for you. You don't know who wrote the document. You don't know for whom the document was written. You don't know the type of business the document was written for. And we're going to talk today about some specific policies that are unique to operating a brewery that you should have reflected in your employee handbook. You don't know when the handbook was written. So from a compliance standpoint, like, is this thing up to date? You don't know when it was written. And you don't know in what state it was written for, right? What state law does that handbook comply with? Or is it kind of an amalgam of states that don't make a difference? Because there's lots of, 50 different states with 50 different set of state laws. It's the beauty of, our form of government, but it makes compliance difficult if you pull a handbook that's written for California, which has lots of laws that an employer in my state, Ohio, we don't have to comply with. And so you don't want to do more for your employees than the law says you have to. You need to make sure that your handbook complies with the laws of the state in which you're operating. So if you want to save a few nickels, cut a few corners, by all means, go to Google, find the handbook. But before you roll that handbook out to your employees, call up your employment lawyer, have them give it the once over and bless it as, yes, this is a 2023 handbook that's compliant with fill in the blank with your state, to make sure that you are not giving your employees something that is either going to be flat out illegal or is going to do more for them that the law might otherwise might require you to do for them. Okay, I talked at the opening about you not wanting your handbook to be a contract between you and your employee. We're going to talk over the next 45 minutes or so about a whole bunch of policies that your handbook either must have because the law says it must be in your handbook, or should have because from a compliance best practices standpoint, these are the policies that should be reflected in our handbook. But what you don't want is a situation where, whether it's a must-have policy or a should-have policy, you don't follow that policy and you open yourself up to an employee coming and suing you for breach of contract. So unless you want your handbook to be a contract of employment, and I strongly, as strongly as I believe just about anything in my practice, strongly believe that you don't, then you need in the handbook itself to affirm the at-will employment status of employees and disclaim that the handbook creates any kind of contractual relationship between your business and your employees. Separately from that, you should get a signed and dated receipt from the employee that you put in the personnel file, so that if a question arises down the road, if you need to call me or your other friendly neighborhood employment lawyer and say, so-and-so is suing me for X, Y, and Z, and I or someone else needs to depose that person, there will be no dispute over whether that person received the handbook, because you have a signed receipt from that individual dated that they received the handbook on this particular date. They read it, they understood it, they had the opportunity to ask questions, and otherwise they got the handbook. So it makes my job a lot easier, which consequently is going to make your job a lot easier in defending against a lawsuit if, God forbid, you have to defend against one. I talked about these kind of policies going into two buckets, kind of should haves or nice haves and must haves. This isn't a must have policy, and we're now going to run through the various policies that must or should appear in your brewery's employee handbook. But it is as close to a must have policy as you should have in your employee handbook, and that is an equal opportunity or equal employment opportunity policy. It is your commitment on paper to treat everyone equally, regardless of their race, their sex, their gender, their sexual orientation, their gender identity, their national origin, their religion, their age, their disability, their genetic information. In Ohio, for example, where I am, we protect military status as a protected class. Whatever other statuses are protected by your state or local laws. In addition to these federally protected classes, you need to put that out on paper, and you gotta live it, right? Particularly when we're making commitments like this to treat everyone the same, regardless of whatever protected class they happen to fall in. It's one thing to put it down on a piece of paper. That piece of paper becomes meaningless if you don't live it every day in how you operate your business. And that's a topic for another webinar on another day, how you make good on your DEI promises to your employees and the public. But for purposes of today, get it down in a policy statement in your handbook. Make sure employees understand what your commitment is to treat them equally and equitably, regardless of their protected class. Make sure they understand how they make complaints if a complaint needs to be made on some discrimination issue. I'll repeat this again when we talk about harassment in a minute, but it's not enough just to say report unequal treatment to your supervisor, because if, for example, the supervisor is the person that the individual feels is treating them unfairly or unequally, they're not going to feel comfortable going to that person to make a complaint. So they need to understand you need to have multiple avenues of complaints for individuals to raise these issues with management. Talk to your supervisor, talk to human resources if you are large enough to have a human resources department. Talk to any member of management or ownership. Have multiple means for employees to raise discrimination issues within the workplace. And then absolutely need to have a promise of no retaliation. You will see this repeated several times throughout today because, frankly, Lots of businesses get the front end promise correct. We're not going to discriminate. We're not going to harass. But where they get things wrong is then the retaliation piece on the back end. Someone complains and then they're disciplined or they're fired or whatever. And so we need to make sure employees understand, and you live this, right? Employees understand and you live this, that there will be no retaliation for employees that bring complaints of discrimination to your attention. A reasonable accommodation policy also falls under the umbrella of equal employment opportunity. When we go back to the equal employment opportunity policy for a second, we see within the umbrella of protected classes, we see scheduled out disability and religion. And disability and religion under our equal employment opportunity laws hold a special place, because in addition to you not being able to discriminate against employees because of those two protected classes, both disability and religion carry with them affirmative, reasonable accommodation obligations. If an employee needs a reasonable accommodation to perform the essential functions of his or her job because of a physical or mental impairment, a disability, you have to make that accommodation to allow them to perform their jobs, unless it imposes an undue hardship. And for the purposes of today's webinar, that's all you need to know. And again, that's a full hour with you all in another day explaining the reasonable accommodation process. But it is an interactive process, both for disabilities and religion. So disability, to perform the essential functions of the job, that they're impaired because of a physical or mental impairment, you have to provide a reasonable accommodation that will let them perform those essential functions. Similarly, if an employee holds or has a sincerely held religious belief, practice, or observance, and they can't perform their job because of it, you have to accommodate there as well. And employees should understand what that process looks like. It's in both cases, it's an interactive process. It's a conversation between you as the business, the employer, and the disabled or religious employee about what's needed. It's a conversation. It's a give and take. What can we do for you to help you perform your job? And you should explain that interactive process and your obligation to reasonably accommodate in the handbook how employees should make requests. You can, for example, you can ask that requests be made in writing, but you cannot deny an accommodation. For example, if someone just makes an or request, but you can certainly ask that requests be made in writing so you have documentation. And again, avenues for complaints, same with the EEO, Equal Employment Opportunity Policy, avenues for complaints, multiple avenues for complaints, supervisor, manager, human resources department, any member of management, ownership, whomever, should be able to take a complaint over a violation of a policy, particularly one that you have a legal obligation to carry out, such as a reasonable accommodation. And again, as I said earlier, no retaliation, and that should really be in big, bold, red letters, because it really is that important. Anti-harassment and anti-bullying. So bullying in and of itself is not illegal. You can be if you want to be. It's a terrible employment practice. You will have a revolving door of employees and lousy reviews on Indeed, Glassdoor, and everywhere else by employees who thought you were an awful place to work because you treated everyone like garbage. But bullying, that is being an equal opportunity, just awful person to work for, is not illegal. What is illegal is being an awful person to work for and treating people poorly because of a class that the law protects. And again, we talk about the same classes we talked about before: race, sex, sexual orientation, gender identity, religion, disability, national origin, age. Whatever classes the law protects from discrimination, the law also protects from illegal harassment. Your policy should define it. We typically think of sexual harassment, but it's not. Again, it's any category the law protects from discrimination. It also protects employees from harassment in the workplace. We need a similar reporting procedure as we talked about before. That is, any member of management, any supervisor, anybody in human resources, any member of ownership, anyone in a position of authority within the business should be able to take a complaint of harassment and then get it to the right person to the next step. What's the investigation procedure? And that should be detailed in the policy as well. No promises of confidentiality, meaning you should assure employees who bring complaints of harassment to your attention that you will do what you can to keep their identity as confidential as possible, but you have a legal obligation to investigate, to do something about it. And that may mean that their identity might either be explicitly or implicitly divulged as a result of the investigation, and there's just nothing you can do about that. So you do everything you can to protect confidentiality, but you can't guarantee it in all cases. Again, for the reasons I stated before, no retaliation, all bold, all caps, big red letters. And even though bullying is not illegal, I think you should, because we should have a culture in which employees are not mistreated regardless of the reason, and should be able to complain about mistreatment regardless of the reason, whether it's a legally protected reason or not. We should treat bullying, that is just being a jerk to someone, not because of a protected class, but just because, we should treat that the same and take the report, engage in the same investigation, and then correct it on the back end to the extent any correction has to be made to the offending employee. This policy, for an anti-harassment, at least the illegal harassment piece of it, falls into the must-have category of policies. You cannot not have an anti-harassment policy. Some states, like California, expressly require it along with annual anti-harassment training. But more generally on the federal level, there are certain defenses available to you under the federal workplace discrimination laws that you will not have available to you if you don't have a workplace harassment policy. So this is an absolute must-have. No employee handbook is complete without an anti-harassment policy in it. Training and orientation policy. We're going to talk about a couple of policies that I see in employee handbooks as I've reviewed hundreds, if not more, over my career. And lots of them have policies in them that are, for whatever reason, holdovers from old collective bargaining agreements. Union contracts have things in them called probationary periods. Union contracts, if you're a member of a labor union as an employee, you're not an at-will employee. You have just cause protections. You can't be fired without cause. Non-union, no contract. You're an at-will employee. You can be fired for good cause, no cause, or bad cause, as long as it's not an illegal reason. But lots of employee handbooks carry over this idea of a probationary period from a union contract. Because union contracts create just cause termination rights, they often have built into them probationary periods that say, like, for your first 90 days of employment, you're at will, it's your probationary status, you're at will. After that, you become a full employee with the just cause protections under the collective bargaining agreement. By having a probationary period in an employee handbook, you are essentially setting up a false set of expectations for your employees. You're telling them, on day one, we're hiring you, you're an at-will employee. We're telling you you're probationary. And on day 91, at the end of your 90-day or pick your time period, probationary period, you will then no longer be a probationary employee. You'll be a full-time employee. You'll be something else. But you were an at-will employee on day one. You're an at-will employee on day 91 when you come off of your probationary status. So what's changed? Nothing other than a label. And other than your employee is going to think, well, I was probationary, now I'm not, so I must have some greater job protections. They don't. But so it sets up a false set of expectations. What you're really trying to accomplish by having a probationary period is you really want an introductory period between you and your employee. You want to have some period of some get to know you period of time where you can do an initial review of performance, an initial what's working, what's not working, how are you performing, what are you doing well, what do you need work on, what can we do better to support you, are you so awful that there's no way this is going to work out, we're going to cut bait before we even get to the end of the introductory period. You want to have an initial check-in with the employee. So you're really not going to change anything other than what we're calling this. And I suggest then, instead of calling it a probationary period and not having a false set of expectations, that we call it an introductory period so that we achieve the same goal, have that first check-in, that first performance review, that first how are things going, what can you do better, what can we do, what can we do better for you, what's working out well, without setting up this false set of expectations. Other things that we want to define up front for an employee are things like the work week, and that's important because how employees are paid and how overtime is calculated, which we'll come back to in a minute, depends on the work week. So what is your work week? It should be the same for everybody, Monday through Sunday, Sunday through Saturday, whatever it is. Have a work week defined and have it the same across the board for everybody. And then when someone is hired, they're going to be hired. Are they full-time? Are they part-time? Are they permanent? Are they temporary? Are they seasonal? And are they exempt or non-exempt? You should define these terms in the handbook so that employees understand when you tell them what their status is. They have a reference guide so they know what that means. A question came in asking if I've seen instances where new hires are paid differently during an introductory period and get a higher wage after that period ends as standard practice. I wouldn't say as a standard practice, but certainly to bring someone in on an introductory period and pay them, minimum wage, for example, and then at the end of the 90-day period, have a conversation with the employee based on what you've seen in that first 90 days, whether that minimum wage, and have an internal conversation with yourself, whether that minimum wage still makes sense, or through what they've demonstrated in that first 90-day period or whatever your introductory period is. If you think a higher wage makes sense for that employee, I certainly have no problem with that. But I wouldn't go so far as to say I've seen that as a standard practice, but it's certainly not a bad practice to incorporate into your hiring, particularly at some lower level positions. Compensation, meal periods, and rest breaks. Again, when are employees paid? What's your payday? This is important because different states, and again, we talked earlier about making sure your handbook complies with state laws. Different states have different requirements over when employees are supposed to be paid. Here in Ohio, it's no less than twice a month. So every at the halfway point at the end of the month, employees have to be paid. But your mileage under your state law is going to vary. So detailing when employees are going to be paid, how they're going to be paid. Do you require direct deposit, for example, which is something you can do as a legal matter? You can require direct deposit. Are you going to require that you deposit pay into an employee's checking account, or do you have other means available to pay employees? The law makes a distinction between meal periods and rest breaks, and that distinction should be carried over into your employee handbook. Whether you are required to provide meal periods and rest breaks depends on your state law. In Ohio, we have no law that requires meal periods or rest breaks, regardless of how long someone works. They can work 24 straight hours and you are not required to give them any breaks at all. One state to the right in Pennsylvania, if an employee works an 8-hour shift, they are required by law to get 2 15-minute breaks and a 30-minute lunch. The Federal Fair Labor Standards Act then while it doesn't require on a federal level whether you give meal periods or rest breaks to employees, it does dictate how and when they are paid, and makes a distinction between a rest break, that is any break in someone's workday of 20 minutes or less is always, and I thought I had changed this before today's presentation, it's always paid. Always paid. I know the slide says unpaid, but it is always paid. A rest break is always paid. A meal period, which is any break longer than 20 minutes, can be paid or unpaid. The default is unpaid, but you can certainly pay an employee through their lunch break if that's what you choose. And then that's for non-exempt employees. And then also for non-exempt employees, federal law now requires across the board that non-exempt employees who need a lactation break, that is a break in their workday to pump breast milk, have to be given lactation breaks. And those breaks under federal law can be unpaid as well. But if, as a matter of your policy, you pay employees for their breaks, you have to pay them for their lactation breaks as well. Shift beers are a long and storied tradition within our industry. And I have a fair amount to say about them, starting with check your state law on whether shift beers are even legal in your state. For example, where I am sitting now in Ohio, it is 100% illegal to give away free beer to anyone, including employees, with the exception of a limited number of tastings for paying customers. Employees are not paying customers, and if you have a practice of providing a free beer or two to your employees at the end of your shift, and you're in a state in which free alcohol is illegal, your practice of providing shift beers is also illegal. It has to be paid for somehow or accounted for somehow on your books that it is not a free drink to your employees. Regardless, it could be a discounted drink if you're in a state in which free alcohol is illegal. It could be as little as a nickel or a quarter or whatever it is. It just can't be free, regardless of whether the employee is paying for the shift beer at a discount or getting it for free. There are still a couple of, because these are your employees and you are providing them alcohol, there are a couple of important things we need to note. We should have limits on consumption in the workplace. You do not, as a matter of practice, want your employees getting drunk at work and then getting in their car and driving home, or stumbling out into the business and acting the fool in front of your customers. It's a really, really bad look. And if they get behind the wheel of their car, for example, not just a really bad look, but if they do something, get in an accident, God forbid, kill somebody, you're on the hook as the server, as you all well know. There should be zero tolerance for company vehicles. If they're in a company vehicle, there should be no alcohol consumed whatsoever. If you have employees working beer festivals, my suggested best practice is that you provide rides back and forth, or at least a ride forth coming from the beer festival where alcohol is likely going to be consumed. Reaffirm in your policy the right to deny a shift beer or further shift beers if it appears an employee is intoxicated, and then further the right to deny for an employee that has a history of DUIs or substance abuse, that you should reaffirm the right to deny shift beers in that instance as well. So I understand a well-time honored tradition in our industry. Believe me, I'm the last one to play the buzzkill here. But if I take off my brewery hat and put on my lawyer compliance hat, this stuff always makes me really nervous because alcohol is involved. And so there are just a lot of boxes to check, and making sure that we have expectations clear with employees. It's best to put it in a policy within the handbook. Timekeeping and overtime. This is important, particularly in our industry, because of the prevalence of wage and hour lawsuits against hospitality related businesses. 25% of all wage and hour lawsuits nationwide are filed against businesses in the hospitality industry, including those in the brewery business, in tap rooms and the like, brewery operations. And so having some well-defined policies around how employees record time and overtime is vitally important, because it will help safeguard you against a wage and hour lawsuit, which is, I call it legalized extortion. The only people that get rich when a wage and hour lawsuit is filed is the lawyers. It is an unpleasant experience for a business. You don't want to put yourself in that situation. So some things to consider for your timekeeping and overtime policy. Number one, how are employees supposed to record their time? This is particularly for non-exempt employees. Employees who are eligible to collect overtime has to be recorded, period. It has to be recorded. Your policy should detail how they are to record time, and we're going to come back to that in a second, and I'll explain why that's particularly important when we talk about overtime. But do you have timesheets? Do you have a time clock? Do you have a hand scanner? Whatever it is, a uniform method for employees to record their time. How are employees to address mistakes they feel were made in their pay so they can get fixed? When I'm defending a wage and hour lawsuit, and I do that a fair amount, I love to have a policy I can fall back on that says, when you receive your paycheck, review it. If you feel any mistakes are made, please bring it to the attention of your supervisor, HR, management, whomever, so we can research it and figure out if we need to make an adjustment to your pay. I love to be able to put that policy in front of an employee, a plaintiff, and say, you got the handbook, you read the handbook, you understood the handbook, here's the policy. Why didn't you do this? Why is the first time we're hearing about this 3 years later when you went and got a lawyer who told you should file a lawsuit? Making it clear that falsification of records is prohibited, is a terminable offense. Prohibiting off-the-clock work and requiring the authorization of overtime for non-exempt employees. Those two work hand in hand. If you know or should know that an employee is working, regardless of whether off-the-clock work is prohibited or pre-authorization of overtime is required, you have to pay them for that time. Your remedy in that case is discipline, or in an egregious and intentional situation, termination of employment. But having the policy there so that employees understand the expectation is very, very important. And in regards to having a time recording policy, the case law, the law is very clear that if you have a time recording policy and employees do not use that policy to record their time, you don't have to pay them for it. And so if you require employees to record their time on a timesheet and let them know that if time that is not recorded on the timesheet, we're not going to pay you for, they come back 2 years later and say, but I worked 30 minutes of overtime every day, even though it wasn't on my timesheet. Legally, you have no obligation to pay them for that time because it wasn't recorded pursuant to your time recording policy. And so in that policy, it's not just important to let employees know how you are recording time or how they are required to record time, but also making clear that time that is not recorded specifically as detailed in the policy will not be paid, period. And that is an A+ defense to an unpaid overtime lawsuit. An unpaid overtime claim, but you can't avail yourself of that defense unless you have that policy in your handbook. Of all the lawsuits that are filed, wage and hour lawsuits in our industry, most of them involve tip pools and tip credits. The laws are grotesquely complicated, and I am going to do my best to synthesize them for you all in the next like 5 minutes or less, so I can get on and get through the rest of the slides. Again, I should say, for those that are going to be at CBC in May, I'm doing an entire presentation at the conference at CBC on tip pools and tip credits. This will whet your appetite, but hit me up at CBC, find me at the conference where one of the afternoons of the conference, we haven't gotten a date and time yet, but I will be doing an entire session just on tip pools and tip credits. But this will be enough to whet your appetite, and then come get the full story at CBC. A tip credit for a tipped employee permits an employer to credit a portion of an employee's tips toward the employer's minimum wage obligation to that tipped employee. So if you have an employee that earns a tipped minimum wage, that is, you pay them something because they take tips, you're allowed to pay them something less than the minimum wage. And again, each state has their own, what is the tip minimum wage in your particular jurisdiction? The tip credit then makes up the balance between that tipped minimum wage and the statutory minimum wage that you're supposed to pay the employee. The tips make up that difference. Key for tip credits is understanding the 80-20 30-minute rule. An employee must be performing tip producing work for you to take the tip credit at least 80% of the time. That is direct tip producing work. And if they are not, even if they are performing tip producing work for the 80% of their working time, if they are not performing direct tip producing work for a 30-minute increment of time, you cannot pay them the tipped minimum wage and take the tip credit for that 30-minute or longer interval in which the individual is not performing tip producing work. The theory is that all employees are owed a statutory minimum wage. If they're not performing tip producing work, then they're not making the tips to make up the difference between the lower tipped employee minimum wage and the actual statutory minimum wage. And so you, as the employer, because you're not providing them tip producing work, you're required to make it that difference and pay them the minimum wage. Tip pooling permits non-tipped employees to collect a portion of tips earned by tipped employees. You can have employees that perform work that supports tipped employees participate in a tip pool. That is, all the money is pooled together in a tip pool, and then non-tip generating employees, cooks, dishwashers, busboys, etc., are then allowed to participate in that tip pool. Importantly, and this is where a lot of businesses screw this up, owners, managers, and supervisors are prohibited from participating in a tip pool or otherwise keeping their employees' tips. The only exception is that if an owner or a manager, whomever is behind the bar, serving drinks, pouring beers, they are allowed to keep tips that they directly earn through their own tip producing work, but as an owner, manager, supervisor, they can't take other employees' tips, and that includes participating in a tip pool. Them participating in the tip pool makes that tip pool illegal, and wait for the lawsuit to be filed. More policies that are important to have: time off benefits. What holidays, if you have holidays that you're closed or employees have the option to take off, what are those holidays? Do employees get sick days? Do employees get vacation allotments or paid time off allotments? How much, how is it accrued? What happens when someone leaves the employment? Again, every state is different in terms of what happens to banks of vacation time or paid time off or sick time when an employee leaves. Do they get it paid out? Does it carry over from year to year? These are all very state-specific rules. And so again, just to go back to the beginning with the danger of kind of online forms, make sure that the handbook that you're using complies with the law of your specific state, so you know that it is compliant with what happens to banks of time off to employees, either year to year or at the end of their employments. Leaves of absences This is both federally specific and state specific. If you happen to be a larger craft brewery that has employs 50 or more people over any of 20 work weeks in the prior year, congratulations, you are now FMLA covered, and you are required to have an FMLA, it's Family Medical Leave Act policy, in your handbook for your employees. But separate from that, even if you are too small, and many craft breweries are too small to be FMLA covered, you nevertheless should have a medical and other leave of absence policy. Think back to the beginning when we talked about reasonable accommodations under the Americans with Disabilities Act, under the disability discrimination laws. One potential reasonable accommodation for a disabled employee is an unpaid leave of absence, an unpaid medical leave of absence. And so we want to detail in your handbook what your medical leave of absence and or other leave of absence policy is, so that employees know how much time is available to them. On the medical side, my strong recommendation is that you don't have it capped. You leave it open-ended and renewable over time. If you have it capped, we're only making 30 days, we're only making 12 weeks of medical leave available to you. Again, think back to our policy on reasonable accommodation. You have an obligation to engage in the interactive process with your employees, and both the Equal Employment Opportunity Commission and almost all courts take the view that if you have a medical leave of absence policy that caps leave at a predefined amount, you are not, as a matter of the policy, you're not engaging in the interactive process, and you violated the disability discrimination laws. Other leave of absence laws that we have, again, some of these are state specific: pregnancy and maternity leave, personal leave, military leave, jury duty leave, voting leave. And there are some states now and some cities have paid medical leave, paid family leave laws. That needs to be documented in a policy. California, for example, has an organ donation leave law. That needs to be documented in a policy. Some states have domestic abuse leave laws. That needs to be documented in a policy. The point is, you need to do, or more importantly, engage a lawyer who's knowledgeable in these issues, who's going to make sure that all leaves of absences to which an employee could be entitled in your state are accounted for in your employee handbook. Performance and discipline standards is important to have in a handbook. How are you going to hold employees accountable? When we talked earlier, when we were talking about probationary periods, we talked about holdovers from old union agreements. Another one that I often see is progressive discipline, and that is a formal, hard-structured progressive discipline policy. On the first violation, you will get an oral warning. On the second violation, you will get a written warning. On the third violation, you will get a second and final written warning. On the fourth violation, you will be terminated. We need to remove these kind of hard followed steps from our idea of the right way to discipline employees. It's not. We want to have discretion. We want to have the following as a list of unacceptable behavior, any of which could result in discipline up to and including termination. You want to treat similarly situated employees the same across the board for the same infractions, but you don't want to be so rigid that what you're going to do is going to be baked into your policy, because you need to allow for variances among situations, among employees, because one person's violation that could result in a termination might be another person's first warning or second warning, or whatever. So have your list of acceptable behavior, but build in discretion so that employees understand that you have the right to fire or discipline depending on the circumstances and the severity of a particular situation. Attendance and tardiness, I try to move employees away, or move employers away from like point-based attendance systems. It creates issues, for example, under the Family Medical Leave Act and disability discrimination laws, because you can't point employees for medical or disability related absences. And it just creates an administrative nightmare for businesses. They're trying to decide, can we point here? Shouldn't we point here? I just think you treat attendance and tardiness like any other performance issue. When it becomes, you'll know when it's an issue for an employee, and you counsel and discipline and ultimately terminate when necessary. I want to make one note about confidential information. I would say 50% of employee handbooks that I don't write, that are put across my desk for me to review, contain a policy that says something like wages, pay and wages are confidential. It's a terminable offense to discuss how much you earn, your pay, your salary, your wages with another employee. Please keep such information confidential. That policy is on its face per se absolutely illegal. Employees under the federal labor laws have an absolute right to discuss between and among themselves wages, hours, and other terms and conditions of employment. And if you have a policy that prohibits them from talking about how much they make, you violated federal labor law. And so that type of confidentiality should be removed from handbooks and other policies. The confidentiality I'm talking about here is confidentiality about sensitive business information, right? Your recipes, your operating procedures, your financials, things like that. Information that is confident, that you want to keep confidential to the business, that another business could a competing brewery could do damage you if they got a hold of it. That's the kind of information we're talking about here when we talk about confidentiality. Dress and appearance policy. I'm not a huge fan of dress codes. I think keep it professional is probably good enough in most cases, and professional is going to depend on professional for what. What does professional mean in your brewery? That's what your dress code should be, and enforce it accordingly. Non-solicitation, meaning making sure employees understand that they should not be soliciting other employees for anything on working time. Solicitation should be limited to non-work areas and non-working time. And then detailing when employees' performance is reviewed, how, and then if you don't have to give employees a right to review their personnel file, but if you want to, detailing that here as well. Safety and workplace accidents, another good policy to have. How are employees to report accidents or unsafe working conditions? Again, big, bold, capital letters, all red, no retaliation. Making sure employees understand, if it's not already spelled out in your conduct policy, that violence and horseplay are prohibited. Firearms, you can prohibit firearms from coming into and other weapons from coming into your workplace. Check your state law and whether you can prohibit them from your property altogether. Again, Ohio, where I am, employees can keep a weapon locked in their car. They can't bring it into work if you prohibit it, but they can keep it in their car. I don't want to get into a debate on gun control, but we can debate the sense of having employees having weapons on your premises. What's your smoking policy? If employees smoke, where are they supposed to smoke? What's your drug and alcohol policy? Do you test? And if you test, when? Do you have pre-hire testing? Do you have post-accident testing? Do you have reasonable suspicion testing? And do you have random testing? And if you do, for drugs and or alcohol, what does that look like? What does that program look like? Vaccine policies have been in the news a lot, obviously, because of the pandemic over the last 2 years. And if you're requiring vaccinations, that should be spelled out in a policy, as well as whatever exceptions you're going to allow for reasonable accommodations, as I said earlier, for disabilities and religion. And then a fire safety policy as well. If there's a fire, what are employees supposed to do? Electronic devices and confidentiality. We hit confidentiality here again because I believe it's that important. But if employees have your device, right? What are your expectations for how they're going to use your device? If they have a company issued cell phone, landline phones, computers, internet, social media, who owns it, that there's no expectation of privacy on devices you own, that you have the right to surveil it. And if it's their device that is connecting onto your network, making sure they understand what privacy rights they're giving up through the convenience of having one device that for everything as opposed to a personal device and a private device. Dispute resolution. The quickest way to solve most problems in the workplace is to talk about them. I know some people think talk is a 4-letter word. It's not. But having an open door policy and having that policy mean something substantive and meaningful, that you're going to not just have your door open so that employees are comfortable coming to talk to you, but that employees genuinely are comfortable coming to talk to you because they know you're going to listen to them and at least take their complaints seriously. And then do you want a more formal grievance or arbitration policy? Again, when we think of union settings, that's a holdover from those settings. I don't like those in non-collectively bargained workplaces, but you might decide you want something more formal than just an open door to resolve employee issues. And if you want to do that, it's something you should certainly have in your handbook. And then finally, what happens at termination of employment? If someone wants to leave you, are you going to require advance notice of resignation? We don't have slavery in the United States. We haven't since 1865. You can't require someone to work for you. Even if you require 2 weeks notice, you can't require them to stay. They're free to walk out the door at any time. You can put triggers that might entice them to stay. So you might say, we will only pay you your accrued paid time off if you honor your 2 weeks notice, for example. So there's ways to entice employees to give their 2 weeks notice. Do you do exit interviews, and what does that look like? How are you going to get your property back, and do employees understand their obligation to return your stuff at the end of their employment? COBRA, whether federally or states have their own. For small, COBRA on the federal level covers businesses with 20 or more employees. If you're smaller than that, most states have their own COBRA for continuation of benefits at the end of employment. How will final paychecks be handled? Again, check your state law. And what's your policy on job references? That is, in about an hour, a run through of just about every policy you want in your employee handbook. This is not designed by any stretch of the imagination for you to be able to take this and run and write an employee handbook. It's really designed to give you a sense of issues to be on the forefront of your mind when you are having a handbook written for you, to make sure you're checking all your boxes. And when you're dealing with your employees, what issues should you be thinking about in your day-to-day dealings with your employees? I know we're right up against the 5 o'clock hour. I'm always sensitive to time, and I do want to open it to questions. But before I do that, while I have an audience, I just wanted to make everyone aware of a product that we just launched here at Wickens Panza. We're calling it Craft Brewery Counsel on Call. It is a legal subscription service for craft breweries, specifically tailored to the needs of craft breweries. It comes in 3 sizes, pint, 6-pack, and keg, depending on the size and needs of your brewery. The information is in the slides. If you want to read it, you can go to ohiobeerlawyers.com, which is the website for our craft beer practice. There is a link there to a PDF that will give you all this information. This is really designed to give the small business owner certainty in their legal spend. I never want to have to try and fix an issue on the back end that could have been fixed on the front end because someone was afraid to pick up the telephone and call a lawyer because they didn't know how much it was going to cost for the lawyer to pick up the phone and answer a question. This service is designed to remove that friction from the process by having you subscribe to our menu of legal services and have us available to you on call as needed, and you know what your bill is going to look like at the end of the month, depending which suite of services you subscribe to. For purposes of comparison's sake, the employee handbook is in the middle tier. So if you want more information, ohiobeerlawyers.com, or you can email me, jhyman at wickenslaw.com, or hit me up at any of the other contact avenues I laid out at the beginning of the presentation. So with that, again, I want to give a hearty thank you to Andrew and to Laura for setting this up. I know I threw a lot of information at you. If people have questions, I am happy to take them. Otherwise, I'd like to again thank Andrew and Laura. Wish everyone well, and cheers. Everyone have a great day.